case. Joining me now is former Manhattan District Attorney Cyrus Vance, who preceded Alvin Bragg, and it was Vance's office that began this investigation. Cy Vance, welcome to Meet the Press.
Good morning, Chuck.
So let me just start with the basics here. You began this campaign in 2018. I know you haven't read the indictment, but if you could perhaps help us sort out, what does it look like the charges are going to be on Tuesday morning?
Well, Chuck, the truth is, as you've already commented, I haven't read the indictment. And we've read a lot about what the indictment may be about, but I think we all have to sort of take a pause here and wait until the charges are released in court on Tuesday. If the charges are exclusively along the lines of the reporting before I came on, it'll be a Class E felony, and there is a upward range that involves prison and a downward range, as you noted, that involves no prison whatsoever. So that's what we have to wait and see. Really, only District Attorney Bragg knows what the evidence is. That's another thing we all have to be mindful of, that we can speculate on what evidence we think they may or may not have. But even with the indictment published, we really will not know what the district attorney's evidence is and what they would present at trial.
The Associated Press is reporting of at least one felony charge. Do you expect this to be more than that, or is there probably only one charge that will be, as you described it, a Class E felony?
That I don't know, Chuck. But even cumulative numbers of counts of Class C felonies won't necessarily increase any exposure.
Do you expect this to be a speaking indictment, essentially laying out the facts in some detail when we finally get it unsealed?
I would anticipate, although I obviously don't know, that it would be a speaking indictment. And our office, when I was district attorney, used speaking indictments appropriately, I think, in order to explain the background facts that lead up to the specific charges in the indictment. I think it's a mechanism by which the public official can explain in a public and legitimate way why the case is being brought and what evidence, generally speaking, can be anticipated during the trial.
Let me read for you an editorial from the Washington Post just after the indictment was made public. Here's what they wrote. This prosecution is now bound to be the test case for any future former president, as well as, of course, proceedings against this former president. A failed prosecution over the hush money payment could put them all in jeopardy, as well as provide Mr. Trump ammunition for his accusations of, quote, witch hunt. This prosecution needs to be airtight. Otherwise, it's not worth continuing. Is there any doubt in your mind that this case is airtight?
Well, I do not know if this case is airtight or not. I know that the DA's office has extremely experienced and seasoned lawyers. This is, the charges that might be involved here are certainly well within their experience level and their trial experience level. The quality of the evidence, again, we must relate to. But when you look back on the investigation, Chuck, I mean, one has to remember that we went to the Supreme Court twice, our office, in order to get the financial documents, which were finally released to us by the Supreme Court, and that resulted in an indictment of the Trump Organization, as well as the CFO, the Trump Organization being, in effect, an alter ego of the president. The life continued after that event. The case was tried. It was a very strong case. The court imposed a fine, but the world didn't stop because the Trump Organization was indicted by our office.
Why didn't you charge the hush money case? Why didn't you ever charge it in 2018, 2019, 2020?
Well, Chuck, I don't want to get into the deliberations that might be covered by grand jury material, but as I believe you know, I was asked by the U.S. Attorney's Office in the Southern District to stand down on our investigation, which had commenced involving the Trump Organization. And as someone who respects that office a great deal and believing that they may have perhaps the best laws to investigate, I did so. And I was somewhat surprised after Mr. Cohen pleaded guilty that the federal government did not proceed on the areas in which it asked me to stand down. By that time, we were also well on our way in a financial investigation that ultimately led to subpoenas, which the president himself published in a lawsuit he filed against me in the office, and ultimately that long but successful journey to the Supreme Court. And for those who think this is about politics, I think it's important to remind folks that the review of the president's objections to our seeking his tax and other financial records were reviewed by 2 separate district courts, 2 separate courts of appeal, and twice by the United States Supreme Court, all of whom found no evidence that politics was motivating our actions.
Did your office conclude that a standalone felony charge for these hush money payments wasn't worth it because of so many of the uncertainties around the legal theory, and that's why you were pursuing this larger issue, that this was just one part of how the Trump organization either lied or on their business records?
Well, I think, Chuck, again, I don't want to get into our deliberations, but we have historically filed cases of false documentation, elevating them to felonies when federal statutes were involved. It's never been done that I know of with regard to federal election law, which is quite a specific area of law. But I think the question is not so much why didn't I do it or we did it, but why this district attorney is doing it. And that really requires us to be patient and to wait. Yeah. This process isn't going to be accelerated by us talking about it. It's going to be moved by the court at the pace the court sees fit, and I guarantee you the court will want this to move quickly.
Would this case be stronger? Would you have brought this case yourself before you left office had the Alan Weisselberg, the former chief financial officer for the Trump organization, cooperated?
Well, ultimately, Mr. Weisselberg, of course, did testify at trial and provided, I'm sure, relevant evidence. I think his cooperation perhaps was not what the district attorney's office hoped, but nonetheless, I think he was a key witness at trial, and the jury, beyond a reasonable doubt, found the Trump organization guilty of 17 counts, 17 felony counts. So I think his testimony was very helpful, is my belief. Mm-hmm. But I think, although I was not in the room, I think he did not provide full cooperation in testifying against the president himself.
Mark Pomerantz, who you brought in to help with this Trump case, a former federal prosecutor. He was in private practice. You brought him in. I had him on this show in February, and he said essentially that you had greenlit an indictment on a sweeping financial fraud case to do that. Had you?
I don't want to get actually, Chuck, into my deliberations and internal communications, but I can say this. Were I to have greenlit the continuation of investigation toward indictment, I also understood, for reasons that were just specifically about the time that we had, the delays going to the Supreme Court, the delays occasioned by the Southern District's request for us to stand down. COVID was in the city during this investigative time period and had a material impact on our ability to get grand juries to sit and obtain evidence. So from a time perspective, we had some unfortunate coincidences that kept us back, not going as fast as we could go, because we were trying to move as fast as we could. Mm-hmm. Ultimately, I knew, however, that because I was not able to be the district attorney at a time when all the evidence was in, that this was going to be District Attorney Sprague's call. I may have made a different call than the district attorney did on the case that I had, right, or we had. But when one is out of office, really it's the district attorney's prerogative to look at the case afresh. He did, and then you've seen where he has pointed his team, resulting in the indictment today.
Look, again, with all the stipulations and caveats that we haven't read the indictment, we know that the Trump legal team is going to try to get this case thrown out for a couple of reasons. One will be claiming that the novel legal theory, meaning this first legal theory that Alvin Bragg is going to be using to make a felony in state law, whether that is applicable here There's the issue of Michael Cohen's testimony, and there's the issue of the statute of limitations. If you were the prosecutor, which one of those three hurdles would you see to be the highest?
Well, I think this is obviously a case of great consequence and a case that's never happened before. So it's novel in and of itself. If I'm guessing about the president's strategy, and it's only a guess, and he'll have excellent lawyers, is that they will take a run at the law first, perhaps on the question of whether or not the misdemeanors can be elevated. That's probably more a question of law than a question of fact, and we'll take a run there first. It would not surprise me if the attorneys representing the former president tried to move into federal court on some ancillary action, as they did with us, and to have that action somehow be reviewed, try to be reviewed on the federal side, and have some impact, therefore, on whether the state court could go forward. For example, asking for a stay because there's going to be an election in a year and a half. In this case, the state case shouldn't go forward. So those are avenues that I think that you'll see. Of course, Cohen will be attacked heavily, but the flip side of that, of course, is Cohen worked for Mr. Trump, and they obviously had a working relationship. So we often find in criminal cases that the witnesses who are involved aren't necessarily, they're not priests or nuns.
Of course.
They are who they are in whatever organization they have.
Final question is this: what's the likelihood?
But I want to add something else, Chuck.
No, go ahead.
Well, I've got to say that I was disturbed to hear the former president speak in the way he spoke about the District Attorney Bragg and even the trial court in the past week. And I think if I were his lawyer, and believe me, no one is called up to ask for my advice, I would be mindful of not committing some other criminal offense like obstruction of governmental administration, which is interfering with or by threat or otherwise the operation of government. I think that could take what perhaps we think is not the strongest case. When you add a count like that, put it in front of a jury, it can change the jury's mind about the severity of the case that they're looking at.
Likelihood this trial happens before Election Day 2024?
That's, that depends, I think, entirely on the judge. Judge Merchan is experienced. He's had already one trial with the Trump organization. The Trump organization and the president are they're tough litigants to control. But he's going to want to set a firm trial date. He's going to want to maintain firm control over all the parties. And that could end up in some flare-ups between the parties and the court as it goes forward. But he's going to. I don't think the former president does himself any favors as it pertains to the ultimate outcome of this case. If he's making more enemies in the courthouse than he needs to.
Cy Vance, the former district attorney for Manhattan, really appreciate you coming on and sharing your expertise and perspective on this. Thanks very much.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.